Good morning again, everyone that's listening or watching. It's 10:54 a.m. April 2nd, 2023, and this is a follow-up and another insert on the corruption in the courts in Jamaica, but with specificity to the ruling of the appeals court that pretty much, when taken in the context of legalities, completely demolished the law on real estate developments and developers, on the mortgage industry, home ownership, and anything related to the industry. That's how dangerous this ruling that was made by Justice Tai is. And when it went to the appeals court, rather than doing their jobs and enforcing the law, they ruled in favor of upholding the ruling that was made by Justice Tai, which is in conflict of the law itself, and I believe has created a number of liabilities for a whole bunch of people, including the real estate board. Because after examining the ruling again and the implication, not only is the Justice Tai's ruling and the appeals court's affirmation of that ruling stating that all developers in Jamaica who don't have a real estate dealer's license are criminals, and that's paraphrasing and simplifying what is factually what they've said in their ruling, is that the contracts are of buying property or developing property or entering agreements with private persons about their land and developing that property by a developer that does not have a real estate dealer's license is illegal and a criminal act. So in short, all the developers in Jamaica that don't have a real estate dealer's license to quote unquote transact real estate business are criminals, and the recipients of the properties that are bought or sold and entering those agreements with these developers unbeknownst to them of the illegality of would be in fact they would also be in fact become participants in an illegal transaction, and so they're criminals as well. So homeowners are in fact criminals, those who bought property from developers. And again, I'll qualify it by saying it's developers that don't have a real estate dealer's license. It doesn't matter about the registration, and I'm going to keep repeating that because it's extremely important that when you have a conversation about this matter and this ruling, don't let people confuse you or you get confused by a real estate developer's registration. There is no, or under the previous law, and I said previous law because what Justice Tai did, and the appeals court just affirmed it, was overthrew the Real Estate Dealers and Developers Act, Section 35, that deals with the real estate developers. They pretty much threw it out. But previously under the Act, real estate developers did not require a license. And so don't get confused with the license that a real estate dealer, and a dealer is a person who do brokerages for selling real estate, managing real estate on behalf of the owners of those properties, selling real estate. So they're not developers, pretty much. That is not to say a real estate dealer cannot be a real estate developer, but there's a designation under the law for simplicity and for clarity. Because in short, if you're going to force the property owner or the developer to get a real estate dealer's license, it wouldn't harm the developer in any way. And what it would do pretty much is require real estate dealers now to pretty much be subject to the developers, as opposed to them operating as an independent entity. Because under the previous law, the law before it was overturned, a real estate developer can sell, can manage, can enter agreements, can enter contracts in terms of buying land and all of that. And again, I'm going to clarify here. There are no laws in Jamaica or anywhere in the world that requires one individual to be licensed to buy property or lease property or manage property or develop property by taking it from another person, either through some lease agreement, purchase agreement, or other. And in our case, it's a joint venture agreement. So there's no license or law requires one to be licensed or get a permit to go buy real estate. There's none. So the implication or suggestion in the ruling by the appeals court and Justice Tai that somehow my company entered an agreement to acquire, managing, and developing property was an illegal agreement is far from being anywhere correct. Constitutionally, it would be illegal because it would be against the Constitution to restrict a person that's owned property from selling it, passing it to another individual who wants to acquire it, whether for development or management. You'd be infringing on your property rights under the Constitution. So that in itself would be illegal. And you would think judges would know that. That said, I promised you I was going to address the issues that on which they claim we were operating illegally. And the primary issue and the issue on which they ruled and overturned the law was basically that my company, Karif Limited, did not have a real estate dealer's license. And they made a number of suggestions in their ruling, including echoing what Mr. Williams, I think Alexander Williams, who represented the client, came with some nonsensical arguments, makes no sense whatsoever. And again, I'll point, not because somebody went to law school means their intelligence level has ever risen. But he came in there with a foolish argument because he knows judges are going to let them play and get away with it because they're attorneys. And a judge is not there to protect an attorney or give the attorney support for foolishness or foolish argument. So this idea of trying to rule against a pro se litigant or a person who represents themselves is in support of an attorney that's not giving any kind of logical or legal argument is again in itself a fraudulent act, corrupt act. So don't think you're getting away with this idea that because you're a judge and you give your body some pass on some foolish ruling, you're exempt from the law from fraudulent transaction act, which is corruption, fraud. Because when you cheat people out of their rights and their property rights and their money in favor of an attorney who didn't even come there with any kind of argument that made sense, then you're participating in also defrauding that person. So you're not exempt from the allegations of being fraudulent, a conspirator in the fraud. Whether you get paid or not, it is irrelevant. Whether you did it because you think they need support or you're trying to ensure that private or personal or self-representing clients or litigants are blocked from the court, and that's your way of doing it, you're committing a crime. Because under the Constitution, every person has a right to access the courts, and you have no legal authority to block that access by giving attorneys who are not performing their duties or their responsibilities to their client honestly a pass. And so when an attorney come in there with some foolish argument about, and in our case, one of the arguments he presented was Mrs. King was confused. An argument which came, by the way, in trial, or a trial, which they should have put, and I looked it up, and it's under Rule 10.7 of the Civil Procedure Rule. If she didn't plead that in our defense in the first place, she can't come into court after how many years and months, and that's the basis of pleading. And so the argument, she was confused. I went over the nonsense they placed why she was confused. And again, it's not for me or any litigant to clarify anything if you're too foolish to understand it. It's for Mrs. King to have come forward and say she didn't understand it, even after we gave her time, 2, almost 3 weeks with the documents. She took them to our attorney, and she came back, and I said personally to her, if you don't understand this agreement, don't sign it. And she signed it and said she understood the agreement. So to come into court and have a judge sit on the bench and say she believed Mrs. King, then something is wrong with that. Something is wrong with the judge. Alright, and then for the appeals court to uphold that nonsense, again, it is saying to me, your motives are not upright. Your motives are questionable. Because there is no way you can tell me after years of signing an agreement, it's when you come to trial then you're going to say, oh, you were confused, and that's the basis of defending about being a joint venture partner in a binding agreement. And the other argument is that if you are so concerned about Mrs. King being confused, and the basis of her confusion is that she wanted to sell her property rather than do a joint venture, then two things come to light. If you were just interested in selling your property, why are you going to take part of our profits? Part of the agreement, you're getting 5% of the profits. Does anybody, or is anybody who is in earshot of this video and who knows anything about buying property in Jamaica ever see somebody sell their land and then get piece of the developer's profits, and it's a sales agreement? Come on. So don't tell me any judge who hear that argument could even buy into it. So we know it's just not honesty. You judges who did this are being dishonest. And you can't sit there and look anybody in the face and say you could justifiably give a ruling based on that kind of argument about being confused. You're selling your property, and if you were so concerned again about protecting Mrs. King and protecting everybody, because the court is a court of equity, that means you're not there to just rule against people. You're there to ensure that you make the best ruling, the best decision that makes sure everybody is satisfied or protected. And if you were so concerned about an agreement that Mrs. King entered and she said, oh, she only wanted to sell her property and sell it for less than we were willing to have her make off it now, remember. So again, this is another factual argument that makes no logical sense. If Mrs. King is selling her land to us for a figure which we put in, I think it was approximately $2 million US, and she's going to be making significantly more on the joint venture than the $2 million, and you say she was confused, then just restructure and rule that, okay, Mrs. King, you want to sell the property for $2 million, then we're going to give a judgment for the people to pay the $2 million, and so they can, because you say you want to sell the property. They didn't come to you and say they want to buy any property. But since we are here, let the ruling be, since it's an equitable remedy that the court delivers, let the court rule that, all right, they are going to pay you the $2 million and allow them now to go on to develop the property. You go pay all the stamp duty and the transfer fees so that they can now have the property, because you want to sell the property. You want to sell the property. They want to get the property to develop, and they're willing to pay you $2 million plus 5% of the profit. So it's actually in their favor to say collect your money. How hard would that have been? And dealing with a case equitably. So again, it can't be about judges who just want to do the right thing. That would have been the right thing to do, because we actually ask you in the orders that we saw to have Mrs. King, just simply deliver the titles so that we could get the projects moving. And if you were of the opinion, wrongly by the way, that we needed a real estate dealer's license, all you had to do, if you're about really dealing with people honestly and not defrauding people, is simply say, all right, we grant leave to the developers to go register or get the necessary papers from the real estate board without them losing their money and their efforts and time in developing the property. And so they pay Mrs. King the $2 million or whatever it was. They now can go and apply and get the necessary paperwork from the real estate board if they're required to have a dealer's license, and so everybody can proceed and amicably work it out. I'm pretty sure the real estate board is not going to deny anybody who applies for a real estate dealer's license to get the license. What the real estate board is going to say, all right, you need to do this, that to qualify for it. And it's just a matter of paying a fee and doing a course. So if you are truly concerned about honestly dealing with people and making resolutions to problems that fix issues, as a judge, this is what you do. You know nothing about Solomon. Solomon would have chop off the baby head and give it to this wicked woman if the way you're thinking he thought that way. No, what he did, he came up with a simple solution. You want to kill the baby, this lady wants to take care of the baby and willing to give it up. So let me give the baby to the person who wants the baby to live. We wanted our projects to live to protect our investors and partners. Mrs. King wants out of the arrangement because she sent a letter almost 90 days after entering the agreement that she wanted out. So all the court had to say, all right, the agreement you signed was binding, but because the company you signed with didn't have a real estate dealer's license, which I reinforce again, we didn't need a real estate dealer's license. But since, all right, Justice Tai said, and this is what Justice Tai should have done, but let's say, all right, she didn't do it. She screwed up, period. It goes to the appeals court where you sit down. Three judges sit down there and help to defraud people of their money and undermine the entire economy of the country. Because when you go and call people who buy property from developers who didn't have a real estate dealer's license, that they too are criminals, even though they went into an agreement not knowing that the real estate developer needed a license. They are also criminals and the agreement is void, pretty much. The real estate developer, who under the law is not required to have a dealer's license, is now classed as a criminal. And so you're creating this whole class of criminals who follow the law. They're registered with the real estate board and got their letter of recognition as developers. And then you're going to say, no, they are criminals, and whatever agreements they entered into, it doesn't matter when, how, with whom, are illegal agreements. So the mortgage industry, these guys went into agreements with both the developer and the home buyer, and didn't know that the developer needed a license before he could go build these properties, a real estate dealer's license. And so now the bank is also involved in illegalities, and their agreements with all these people are therefore void. So, in truth and in fact, how do you resolve that, Mr. and Mrs. Judges? How you resolve that? You created all of this mess with your nonsense because you're not thinking. As I said before, I go and call on everything I can call on, just out of anger. But I don't think one idiot is on a bench in Jamaica. I don't think one idiot is sitting in any court in Jamaica. So when you did these foolish actions, why? It spells that you're not dealing with your business that the way you should under the law and under the Constitution. No idiots, but you're not behaving like one. So you want to resolve an issue. Here you have developers and investors who spend the money with Mrs. King, because Mrs. King send a letter authorizing people to become joint venture or investors in developing the property. Don't forget that. And you have that in front of you. So Mrs. King not only now allowed the people to put in their money, which is used to remove the clouds from the property, the title, pay attorneys to go work with the Minister of Housing so the title could be, pay people to design a subdivision plan, pay people to go all over the island seeking to reform to entitle the property so it could be developed, spending money for marketing purposes, hiring staff to do all of that. The people's money was used for all of that, and then you now come and then make this foolish ignorant ruling that the people and money gone. No recourse, no solution, no coming up with any kind of plan to say, alright, this is simple. Mrs. King wants out. She wants only $2 million or whatever it was. So the development, since they're in this agreement and the agreement was entered into, whether illegally or not, Let's remedy it. Let's make it legal. Let's give them time to go down to the real estate board and get the real estate board to give them this dealer's license. And when they get to the real estate board, go and tell them, "You don't need no dealer's license." But that said, you change the law and therefore change its designation. So it's up to the real estate board now and the minister, whosoever regulate the real estate board or manage the real estate board under whose portfolio for, to write to whosoever and make a declaration that real estate developers don't need no license. And whatever the judges did, whatever no need to do, call some special committee, some council, go there and remedy it, because the ruling was so audaciously stupid that it makes no sense. Because judges in Jamaica no make laws. That's parliament. And if there are questions about this law and a dealer, a real estate developer requiring it, what the judges should have done was simply pick up the damn phone and call the real estate board or call the minister and say, "We need clarification." How difficult would that be? Especially when we filed our documents, we mentioned in there when we were appealing Justice Ty's ruling that all Justice Ty had to do if she was confused about a real estate developer needing a license was to pick up the damn phone and call the real estate board and ask them. Pretty sure the real estate board not going to tell the judge anything that's contrary to the law. But rather than doing a simple act like that, which intelligent people would do, if you don't know something, you go do the research and check it out. That's what you do. You don't run blindly in a jungle, not knowing why in the jungle. You check it out first, you know what's in there, what kind of dangers are around the corner, and you check it out. So why would a judge who claims she is intelligent, or a 3-panel judge who are appealing, who work at the appeals court, who supposedly are intelligent, to just blindly take a dumbass attorney word for it? Wanna make no sense. Come down with no evidence, no facts saying a real estate developer needs a license. When I come there with the same argument that Justice Ty relied on, when I put forward about a section of the Real Estate Act that deals only with real estate developer, dealers and salespersons. And in fact, in Justice Ty's ruling, she done state clearly that she never even read the section about developers. And here you go in front of a panel of 3 judges, and not one of them could have come up with the idea, say, "Make we just check the law, call the real estate board and find out if we're confused." Since everybody's so confused over simple logic, simple statements of facts that are written on a document, or since you're not so confused about that, now just pick up the phone and call the minister or the real estate board. All you have to talk to is an inspector down there and say, "Mr. Inspector, do I need a license for be a real estate developer?" They're gonna tell you no. All you need to do is a letter and register. And registering is so flexible because you only register at a certain point if you want to. If you're developing 5 units, you don't need to register. Over 5 units, you're going to develop those 5 units, you register. And you can't register a development if you're buying property from somebody, or buy the property here, because the real estate board have in their policy that the property has to be clear of any liens and anything pertaining. The entitlements have to be kosher, have to be good, before they'll allow you to register that property for development or sale on the open market. Which means, based on the law and the interpretation of the law and the obvious implication of the law, you have to have the property. You have to be able to have permits and all of that from the government. Say you develop this property, that you're going to be building XYZ on the property, before you can take it to the real estate board. So how then would it be illegal for anybody to enter a contract, any contract dealing with land and developing property? How will you come to that conclusion? What kind of logic can you use? Because if the real estate board requires a developer to have the land, to have the development order, to have the plans, to have those plans approved, and all of that from the various ministries before they can come there and register the development, then how the hell can you come and pass some, or make some judgment, or support some judgment, or affirm some judgment that because a person, let's forget about the business now. Let a person enter an agreement with somebody to develop land, it's an illegal agreement because they don't have a real estate dealer's license. When they're not a real estate dealer, they're not selling and buying property for people. This is property that's being acquired for their own personal activity or private activity. So you want to tell me that judges can't figure them simple statement of law and logic and realize that the nonsense you're doing down there? You're not ruining people's lives with no foolishness. You want to tell me that? And then come and brazenly go say, well, we uphold the ruling of Justice Tai based on some nonsensical argument by Alexander Williams, which no make no damn sense. Up to now, I read his argument last night and just no make no sense. But as I had promised to everybody, and as usual, you should know me by now if you're paying attention to how I function, I don't say stuff I can't back up. I don't make statements that I can't back up or have evidence, right? So here, I'm going to go through some of the documentation. Just briefly, I'm not going to read everything. And I'm going to go over the response from Mr. Alexander Williams, who was put in front of the appeals court, and which they went and supported. All right? I'm going to go over it. Just some brief sections of it. So this is what I had filed in the court. All right? See, just want to make sure everybody have the facts. So these are documents that were filed in the court. So here is his first thing about defense. This is his defense to the user, supposedly for trial. Ground one. This is responding to our claim, of course. Sorry. Excuse me. It is not true to say that the learned trial judge did not rule on the claim. Now we put in the appeal that the judge never ruled on the claim because she ruled on about a joint venture agreement being illegal, and because we didn't have a developer's license, we didn't file any claim even implying or suggesting that. And the court can only rule on a claim when you file it. So we never file nothing like that. So when I'm going to put it is not true that the learned judge did not rule on the claim. And he just make a statement, of course, provide no evidence, no documentation to even support it. And this is what them judges buying to. Somebody, an attorney, because I'm an attorney, I drive around in a little BMW. Because it is not true to say a learned trial judge did not rule on the claim. Well, Mr. Williams, because now Bar Association president, don't know if he still is, but he was. He come and just make that statement and provide no documentation for even support him argument. Because we didn't file any claim about registration as a developer. We filed a claim that Mrs. King violated the agreement we signed. Then I deal with that throughout the trial. Then I deal, even though we pointed out point for point what she violated. Then I deal with that. Then come, it is true to say the learned judge did. No, it is not true to say the learned judge did not rule on the claim. How she going to rule on the claim and we never claim nothing about that? Her written decision and final judgment make it clear that she did come to a decision based on the claim presented by the appellant. Bunch of garbage. Again, you make a statement like that and a court going to buy up that and eat it up and present no evidence, no facts to support it. When we provide a ton of evidence, a ton of facts, and all we present are verifiable, authenticated documents from all over the place, from the Minister of Housing, from the Real Estate Board, from letters from Mrs. King herself, which I'm going to be presenting. And then I present none. This is what I'm coming to court with. The appeals court. The highest court in Jamaica. Alright? And I'm not going to waste time and file nothing with the appeals court again, because I could have filed, say I want to appeal this decision. I'm not going to do it, because guess who? Them say the president, a part of the council will make this ruling, or the committee or the panel will make a ruling like this. And when you file, forgot to the House of Lords or the Privy Council, guess who make the decision whether you can do it or not? The president, the chief justices, So you're going again the conflict of interest, which I pointed out to you in previous tapes. That's why our court, our judicial systems are corrupt, because now we have to go file this to them to say, oh, we need to appeal this, and if the president come and endorse something like this, how are you going to approve us going to file with the House of Lords? Now we can file round it, of course, and then turn it down, but why waste the time? We already waste from 2006 this nonsense are going, right? You never get to trial till 2018, or to the appeals court till 2018. So why should any intelligent person waste their time with a bunch of people who don't give a hoot about their responsibility, and all them going to do is screw around and mess up people's lives and business and undermine the economy of this country? For what reason? I don't know why any of us not resign. There are young people, there are intelligent people, there are people with moral standing and upright in them persuasion to do the right thing that will take those positions. Why none of us left? Alright, so ground 1 and 2. This is defense now. First, it is common ground that the appellant did not have a real estate license required by section whatever of the Real Estate Dealers Act. Remember, the law said we don't require none, you know. So why would I even suggest or admit that we have a license when we're not required to have one? And as I said, we didn't file any claim about licenses from the real estate board, right? Or real estate developers license. And you said it's kind of tricky, deceptive language which fall under the fraud, the law from Fraudulent Transaction Act. Remember, I pointed out in the previous videos that under that law, any kind of trick or deceptive move to fool anybody trying this matter or hearing this matter is a crime under the law from Fraudulent Transaction Act. So this little tricky argument or playing with words, semantics, is what I'm often do in court. And judges supposed to know this. The judge never catch this. Say, our real estate developers license. So here I'm the same something. And they say, the business didn't have a real estate dealers and developers, a real estate license required by the section of the Real Estate Dealers Act, which is nonsense and untrue. Did the judges go there and check it? Because under that section that in quote here, section 10 subsection 1A, under that subsection there's nothing in there that states that a real estate developer is even covered under that section. So did these judges gotta go read it? No, because you couldn't tell. And let me not say no anyway, because I am suggesting there's nefarious, irresponsible action on the part of these judges, and if they had gone there and read it, there's no way they could have come up with such a decision. So them probably A, never went there and read it, 2, then go there and read it and ignore the law and just decide they're going to screw around with people's lives and rule against us. For what reason? They want to block pro se litigants or self-represented litigants from coming in front of the courts. Because that could be the only reason. Or they're trying to take revenge against me because I am so vocally outspoken, I'm so loud with the corruption that's going on, and determined that I'm going to be exposing it. And not only exposing it, I already put it online. I file it with all kind of law enforcement agencies around the planet. So even if I'm taken out or I'm dead tomorrow, the evidence is there, and this is further proof of the garbage that's being done in Jamaica and the corruption. Alright, so here under this section 10 about Real Estate Dealers Act, it says, they went on, nor a real estate developer's license. And I'm reminding you again, pay attention, license. No developer in Jamaica required a license. What they required is to register themselves with the real estate board and get a letter from the real estate board that they are real estate developers and they're pursuing a specific project and the nature of the project and all of that. And then the real estate board direct those people. One who can do, one who can't do. No can't collect money at this stage. No can't do this until this is done. No can't. This is what the section 30 or 35, I'm going to probably come to it, that deals with real estate developers. There's no such thing as a real estate developer's license, and the judges should know that. Alright? So, and he goes on, under section 35 of the act, at the time the appellant entered into the joint venture agreement. Alright, so him talk about section 10 up here now, which is a different section. And then he goes say, under the real estate developers section of the act, which is section 35 of the act, we didn't have a real estate developers license at the time we entered the joint venture agreement. Remember, section 35 deal with the developers, deal with no license for no developer. All they're required to do is register. And I again always suggest and recommend, don't just take my word for it. Take the time to go pull up the act. You have internet. If you're listening to me, you have internet. Go in there and just search Real Estate Dealers and Developers Act of Jamaica and read the various sections, and you'll see for yourself. And if these are judges who are supposed to review matters and they deal with law and deal with facts, if they read these sections, no way under heaven could they come up with such a decision supporting something that Justice Ty did. Alright, you hear him say, okay, trial. So neither the license nor the registration had been referred to in any witness statement. Him change it now from license to registration, So the bastard well know, say him a trick up or play a trick. And the judges sit down there. Is it that they're so silly that them have this person that play with them like a yo-yo? And then I recognize that the brother has said to them in one instance, a license, and then he going to put down and say now the registration. Alright? So him well know say it's a registration that's needed. Was not mentioned in a witness statement. In any event, they apparently admitted this in cross-examination, which is garbage. Lie. Why would I write in all my documentation, including making statements here, that we weren't registered as developers, even though that was not part of our our claim. And I'm pointing that out to you because the constant lying is always proved. Him say we don't mention in no part, nowhere in our argument or legal filings we mention that we were registered with the real estate board, even though that was not part and parcel of anything we needed to put forward, because all we went there about is an agreement. And how to be a real estate developer or real estate dealer to enter any agreement with anybody. If you're a real estate dealer, you're representing somebody, then you have to have your real estate dealer's license. But a real estate dealer buying property on his own for use it for his own purpose or even for developing does not require a dealer's license. From that perspective, that is personal business, and a developer does not require a dealer's license. But the liar went and put in front of the court, and they're pretending they don't know what's going on, because I just pointed out the semantics, the using of words and playing around. And so this is the particulars of claim. And the particulars of claim is what you file, listing why you're filing the lawsuit. Alright, so this is what we filed and had in front of the court. And I have here at the note between paragraph 20 and 20, in keeping with section 3 of the act, the claimant made certain statements, and I'm just going to read just one. The first claimant, which is the company, is a company registered with the Office of the Registrar of Companies and the Real Estate Board to carry out the business of real estate development. So I said the liar just say up here, so we know make no registration, we don't mention it in any documentation, and in the most important document in a claim that you file, the third paragraph in that document. And all of this is on the court records as usual, So if you want to go pull it up and check it, do it. The first claimant, which is Carif Limited, which is the company them say illegally enter a joint venture agreement, even though we never need no license or permission or letter for enter any kind of agreement or contract for buy, develop or anything about land. That is not the purview of the Real Estate Dealers Act. The purview of the Real Estate Dealers Act is to say when we get to the point of getting ready to go sell the property or put it on the market, that's when we are compulsory needed or mandated to register that particular development. And in our particular instance, we already had development that were approved, so we filed those with the real estate board. And here we're stating, for the court to understand that when we entered this agreement with this woman, we and currently when we filed this claim, we were already registered as real estate developers with the real estate board. So this whole argument about we being illegal and operating illegally, even if we were required to be registered with real estate board, we were already registered. But the point I'm making here's this simplistic individual, think him so brilliant, coming in, we're playing with semantics and twisting and twirling a bunch of judges who are not paying attention to say, oh, we never mentioned it in any legal documents that we were registered with the real estate board. Paragraph 3. The first claimant is a company registered with the Office of the Registrar of Companies and the Real Estate Board to carry out the business of real estate development. Is that clear enough? Then it goes on to say that the first claimant offers joint venture partnership in real estate with property owners. So I don't say we sell nothing to these property owners. We enter a relationship, a contract to develop the property. So in short, we technically are the agents or developers, employees of the property owner with the joint venture. So you want to tell me so a property owner can employ or make arrangements to pay a real estate developer to develop the property by saying, all right, we're going to do this. In this agreement, you're going to develop the property, you're going to pay me X amount, and the rest of it is yours. You want to tell me, say, when you invite somebody in for plant yam in your ground, and when the ground come in and bear and you sell it, you said the agreement we had was you're going to plant the yam, and when you sell it, and we make some profit, you take X and me get X. I'm pretty sure you hear about all of that. What part of that illegal? And yet they come with some garbage, and that's why I always say they come with all these case law and present it and bunch up the pleadings in a court as an excuse to say, well, it was based on case law. There are no case laws which give support to any of the argument they put forward, but they have a whole bunch of them there which makes no sense. In a one case, they mention about some man a sell peas. How selling peas compared to people buying and developing land? And I'm serious. I'm not going to waste time going over it. But it's all about some brother needed license to sell peas, and somebody needed for buy the peas, and because the brother never have the license to buy the peas or sell the peas, the person who him enter agreement to sell the peas also is illegal. What have to do with buying land and developing land? But as I said to you before, it's a poor excuse for a judge who come in, and the court should have banned this nonsense. You come in there with a matter, adjudicate the matter on the facts of the matter itself, and not somebody else's case we're gone by. Because an excuse for judges to say, oh well, you know what, authority said that's already, we're going with it. And then they screw up the people's business based on a ruling that occurred at a different time, different place, different circumstances, with different people. How are you going to apply that to somebody's case? So when I go to court and then come with that nonsense, and I cite it too, I cite cases just because they do it. But the fact is, it's an excuse, a poor excuse for say I didn't do it, I relied on authority. That's part of the reform that must be done to the court system. Seriously. So again, pointing out to you that this liar and come into court and make some kind of statement like that. But beyond that, the judge them sit down and accept it, because when you read the judgment, that the appeals court, they mention it. They mention it in there. But we never even filed to say we had been registered with the real estate board. Just pointed out to you that the lies that these people tell because they think we are all simpletons. Alright? So that's the particulars of claim. The joint venture. You can see the big old joint venture at the top. It's a joint venture, and in the body you can probably read Mrs. King and the other parties mentioned in there. The joint venture. So the judge said she believed Mrs. King, said she confused. She never knew she was signing a joint venture agreement. All when I have on my glasses, I can see this big old sin thing that says joint venture. And it says this joint venture agreement made the 13th day of November 2006. You know, so this sales agreement, it says this joint venture agreement, this agreement is made the 13th day of November 2006. So you see, from 2006, these people tie up people's lives with some nonsensical ruling. And instead of just coming up with simple solutions, by saying, Mrs. King, you want your $2 million, and the people are going to pay you $2 million. You're going to allow them to continue developing the property because they pay you for the property. You're just not getting none of them profits. Which is what we're saying said in the documents generally. Since she wants out, the only thing she's entitled to out of the joint venture is the cost of our property minus any kind of damages. What could be more fair than that? We're not going to say to the judge, take away the woman land and give to win and make she go up on the road. We say in our documents, alright, she want out of the agreement, she's out of the agreement. Fine, she quit. She's not entitled to the 5% because she quit the joint venture agreement, and that was part of the joint venture agreement. And she's supposed to get that money according to the terms of the contract or the agreement. Them not do that. So here, the big old up my top says joint venture agreement, and it bear the company seal. So this is a copy of which what Mrs. King had, the court have, and all of them. And it goes on to say, the developer. All right, let me just read that to ensure that everybody. The Caribbean Real Estate Investment Fund, hereafter referred to as CARIF Limited, a company duly incorporated under the laws of the country of Jamaica, West Indies, with registered offices, it used to be in Mandeville at the time, is called the developer, where the context so admits includes its heirs, transfers, and assigns of the one part. So if CARIF Limited even crash and gone about its business, the persons who had an interest in CARIF Limited, that agreement that they're signing would fall to those people. And we did that because, again, as I mentioned yesterday, I don't enter agreements where people risk or increase. We diminish the risk as best we can. And when you make those persons who are part of the company's agreements with the joint venture, and even if the company crash or whatever, the joint venture, the equity and the interests of those companies are passed on to its owners, the shareholders, equity partners, all of that. So these people would be fully protected. Alright, so that's party of the first part. And Valerie King of Paisley Avenue, or Paisley, 19 Paisley something or another, and partners, if any. That means we're saying, if it's not just you have partners that you're not mentioning here, then we also respect them and cover them. And it goes on to say, if any, future and or current. So liberal, we say, we're not here for rob you or cheat you or nothing. So if you have a partner, fine. If you don't have one now, but you get one in the future, we'll also respect that relationship. Alright? So this is how liberal our agreements are to protect everybody. And hereafter called a joint venturer. So she now, the land property owner, is a joint venturer of the other part, the second part. And the developer is involved in the business of acquiring, developing, and managing real estate. Whereas the joint venture desires to provide equity in the form of a parcel of land, the joint venturer, that's Mrs. King, is desirous of providing equity in the form of a parcel of land, and the land is in Clarendon, containing by survey, we have that, for the joint venture with the developer for the development, subdivision, and development of property generally. Management, of property generally, described above, and comprised of only vacant land, butting as appearing in the diagrams attached, and the diagram was attached. The parties hereby undertake to carry out their obligations here in the utmost good faith and take whatever steps are necessary to honor this obligation herein. In the event that the joint venture is unable to satisfy, the joint venturer, that's Mrs. King, is unable to satisfy his/her obligation after being served with the requisite notice, then 10% of the investment sum shall be forfeited, as penalty, and the balance due the joint venturer, save any general consumption taxes of 16% at the time. 0.5 for professional services rendered to date shall be refunded to the developer, plus the maximum interest allowed under the law of Jamaica for amount invested by the developer within 12 months or upon sale or resale of the units of the property allocated to the joint venture, whichever comes first. And that is signed by all the parties, including Mrs. King. So what's so confusing about that? A simple, straightforward document that says if you mess up and you can't continue with the agreement, all you have to do is pay us damages. Pay us for money we invested in the property plus interest. What's so difficult about that? Confused? Remember, Mrs. King took the document for 2 weeks to attorneys and then came back and said she fully understood the agreement, but they come into court talking about they don't understand the agreement. Then there was an addendum to the joint venture agreement. An addendum is just an extension of the agreement, or an amendment that takes place after the agreement is signed or entered into. So without disturbing the original agreement, we just simply add an addendum which is signed and agreed to by everybody. The joint venture agreement is and will be amended in respect to current or future promotions by the developer. That was just simply saying we will amend the joint venture agreement to accommodate further promotions in the future by the developer. And those future promotions would include, let's say, promotions may stipulate that additional joint venture venturers will or may be assigned a percentage interest in the development as collateral for capital contributed, and we put an amount that will be contributed. The capital contribution will result in the ownership of a condo, a townhouse unit, or other benefits, including but not limited to equity as stipulated in the joint venture agreement. The venturer is not obligated are required to make any further contribution unless collateralizing additional interest in the development. So we're saying, and we agreed to it, and Mrs. King again signed it, that for the purpose of financing the development, we will have to or may have to bring in additional investors, and we'll admit them to the joint venture agreement by this addendum. And what this is saying, that when they come in, they'll be assigned a percentage ownership interest in the property for their contribution. Because remember, I maintain my objective is to protect everybody. So when you come in and you're putting your money, I feel you must be protected, so you own a piece of the action. You know, just go and buy shares like we want to do, or people do when they're buying an IPO, when a company issues shares or sells shares. You put your money out, you know, get no ownership interest in anything. You own the shares, and if the company crash, then your share is gone. But this is saying, if the company crash, you're part owner in the property that's being held as if you want to put collateral for the development, and you put up your money, so you have an ownership interest in the property. So if it crash on everybody else runway, then you have property rights that's protected under the Constitution and stipulated in this agreement. And in the agreement, it goes on to say the venturer. Remember, we said Mrs. King is the venturer, and we put it in bold. See, big old thing saying venturer, which is Mrs. King, is not obligated or required to make any further contributions unless collateralizing additional interest in the development. So Mrs. King is not required to do anything else within the development of this property. Unless she wants more, then that position is negotiated. Any additional collateralizing will be done at a higher value to be determined by the developer. Meaning if Mrs. King wants to buy one of the buildings, she can't just say because she's a joint venturer, we have an agreement. You have to now come put up more money. You literally have to buy the property from the developer because that is our agreement. And it's just saying if you're a joint venture partner, you were promised a condo, and when we get going, you decide you want 2 more condos. Certainly you can't come in and say, well, I want 2 more condos because I'm a joint venture. No, you have to get the 2 more condos at a cost. That's just part of business, and this is what the agreement is saying. The developer is not obligated to assign any further units of equity or condominiums or townhomes in the complex to any other person or entity beyond those with which agreements have already been signed. Developer has the discretion to withdraw and or to close offerings without notice. This agreement and all agreements relating to this agreement is binding upon signing by the parties, and this was signed on the 13th of November 2006. So this nonsense about Mrs. King being confused, what's confusing about that? And again, she used an attorney. She had it for 2 weeks. She come and she signed it, and then she go in front of a bunch of judges who's supposed to be intelligent and say she confused. That's what our Alexander Williams come and say she confused. All right. So we had to file a lawsuit in 2011 because Mrs. King, after we signed all of that, spend the money to draw subdivision plans, get attorneys to go to all over the place to make sure we get the entitlements correctly done. Mrs. King refused to respond, and she refused to respond because by now, we didn't know this, the housing ministry had already retransferred the title and sent it back to her, and she sit down on it, not saying a word, even though she knew that we were waiting on it. And a letter, so we sent this letter to her on 11th of January 2011. Dear Mrs. King, this notice is to remind you that we have been unable to progress the proposed development to which you have signed a joint venture agreement dated November 13, 2006 with Carif Limited, now trading as Carif.com for property you own in Clarendon. We don't say we own it, no, see, we still say she owned the property, but we have an agreement to develop the property. Registered in, and it gives the title description and it gives the location, so I won't read that. Which you have legally, voluntarily and willingly signed over to us for a legal and legitimate real estate joint venture development project. So you hear about the whole legal, legitimate, voluntary. She signed it over for us to develop the property. The reason for the delay has been the fact that we have yet to receive the retransferred title from you or the Minister of Housing as you had directed at the time, nor have we been informed or kept up to date as to the progress of this transfer. You know, they had the nerve when we went to court to say, oh, but you see how long they take to even send this letter. Now, we have been sending this lady letters and contacting her and no response. So this was the final straw, and they're going to try to use that. They even tried to say, oh, well, the statute of limitation, which was not. Oh, the statute of limitation should run out. It no matter, it never run out. We file it within the statutory timeline guaranteed under the Constitution for financial agreements or whatever, or property rights agreement. We are confident that we will be able to successfully complete our targeted development as we have outlined to you, the Clarendon Parish Council and other government agencies, and therefore wish to move forward as smoothly and speedily as possible. We wish to do so without any complications whatsoever. Now the woman says she only wants our payment for the land, and we are saying we're willing to move forward, we're willing to complete the development and move it forward. Let's just do it quickly without further hesitation or or things that are going to deal us any further. What's so hard about that? All right, so here again, we want to point out that Mrs. King is no victim, and the court here is playing as if Mrs. King is a victim. We are the victims. The investors are the victims, and the court refused to protect us from this kind of scam, this corruption, because they themselves are too corrupt to recognize that what they're doing is wrong, or what they did is wrong, and they need to find a way to fix it, because you're robbing people. And I have a whole bunch of lists of people. I just going to flash it on the screen to show you the amount of people that you people just robbed or defrauded of their money because of own incompetence or corruption. I'm not saying anything less, because it's up to you to prove someone not corrupt by going out and doing the right thing. Pick up the damn phone and call the real estate board or the minister and make sure then tell them say, which they will, because I had a whole bunch of people sitting around the phone on Friday when I called them, so people could hear that we're not lying and we're not playing games. Real estate developers did not or do not require any kind of licensing. Thank you. I won't go on too much longer. I just wanted to point out here, Mrs. King is no victim. All right. Here's a letter from Valerie King, Valerie E. King, Valerine, V-A-L-R-I-N-E, E. King, 19 Paisley Avenue, Maypen, P.O., Clarendon. So Mrs. King robbing all the money. This is where Mrs. King lives. So if you decide to sue, you can go get your own attorneys and sue Mrs. King for breach of promise, because she sent a letter in you telling Carif Limited or its successors in interest that they have permission to go and invite you to become partners or joint venture partners in these developments. And when you put up your money, you're entitled to equity in the development by virtue of the addendum. So in short, you legally have what you call cause of action in the courts against Mrs. King. So even though the judges rule this nonsense about the company, you personally have a cause of action. And I would recommend that you get an attorney and go sue Mrs. King, or you get together with other people, you sue Mrs. King, or you contact me and we get together and we sue Mrs. King and take her through the ropes, because she's not supposed to take with money and with time and energy and just get away with it because of some incompetent judges. Alright, so Valerine E. King, and get the E in there too when you file the suit. 19 Paisley Avenue, P-A-I-S-L-E-Y Avenue, Maypen, P.O., Clarendon. And this letter is dated the 30th of October 2006. And remember, dates are important. So this is the 30th of October 2006. We signed the agreement, the joint venture agreement, in November of 2006. So a full month before we signed the agreement, here's Mrs. King sending a letter appointing or giving permission to Carif Limited to go out and invite people to be part of the joint venture agreement or project, which Mrs. King going to court with our attorney Alexander Williams, and in front of 4 judges say, oh, she was confused, she didn't know what was going on, and the judges victimize the rest of us and tell Mrs. King say she can run with our money and our property, because we have an interest in the property by virtue of what she signed. So legally you're part owner of the property. That's what this spells. And Mrs. King, if she's supposed to get paid for the property, fine, but she owed damages and we have to deduct those damages from it. That's what it amounts to. That's how you do business. That's how a court functions. Court not did for thief people money and just give one person and tell them to go on with it. Alright, so here's a letter to all you judges who it was in front of you. So you can't tell the world say it wasn't in front of you. Here's the letter, and it says Carif Limited, Suite 3 and 9, Sun Village Plaza, and that was the 6 North Course, Racecourse Road, Mandeville. That was when the office was in Mandeville, because we were doing this major development in Clarendon. Our largest market would have been in the Kingston metro area, and we wanted to trap. So we literally moved the offices from Mandeville to Knoxford Boulevard so we could accommodate this project. And that move cost us over $10 million to acquire the space, to renovate the space, and our monthly fees we're paying over $2,000, approximately $2,000 US a month for the space. So you figure the kind of damage that's occurred to us, and therefore in part to all the people who became joint venture partners. Reauthorization for a draft of proposed development and displaying of property to potential investors. So here she's giving us authorization to go draft the development plans and displaying of the property to potential investors. All right, so we weren't just accidentally bumping into Mrs. King. Mrs. King came to us, remember. All right, she came to us claiming one of our staff mentioned us to them, and she came to us. She actually came to our office 4 times after hours in most cases, right? Before we left, she showed up with our other people. And so she's giving us authorization. That means that she's technically contracting us to go develop the plans. And them dummy judges who rule on this have this in front of them, and realize that we became the agents or subcontractors for Mrs. King drafting this. So technically she employs us to draft this, and when people work for you, you're supposed to get paid. And that's why we said in the addendum, if we spent money and time developing these plans, we are supposed to get paid. So that would have been part of any kind of settlement if Mrs. King changed our mind. The judges now look on that and come up with any kind of settlement. Them just said them ruling in favor of Mrs. King because we didn't have a real estate dealer's license, which we're not required to have. Alright? But they changed the law. Remember now, when they made this ruling and affirm it, they technically changed the law. So that law no longer exists. And it's for the real estate board, for the Ministry of Housing or whosoever regulate the real estate industry at the board to come out and fix it. And it's for all the developers who have been criminalized, and all the homeowners who have been criminalized, and all the banks who have now to lose money because all the agreements are void, illegal agreements. Then all of you need to step up and go deal with this. I am not going to deal with it at that level. I'm encouraging people to sue Mrs. King for their money, alright, and the time, and we're going to sue her too. So this game say we're going to go apply to drag it out with appealing to House of Lords and all of that nonsense. No, we're going to sue her for our money and our property rights that's been violated under the Constitution. So we want the real estate board to produce a statement to the world so that when we go back in front of the courts, we don't have to rely on these knucklehead people who can't understand contracts and agreements to interpret laws that they're not supposed to interpret, because the law requires no interpretation. It's written and it's trained and it's plain. And furthermore, the real estate board and the act has been in existence for decades, where hundreds of developers have produced thousands of homes under, and you come with one ruling and decide you're going to make everything illegal. So by convention alone, they were wrong. By law and constitution, they were wrong. They don't have no right to make any kind of ruling like that. Dear Sir, Madam, this letter serves to give to the Caribbean Real Estate Investment Fund, CARIF Limited, a duly registered real estate development company with offices. Here it said duly registered, so Mrs. King knows we're registered with the real estate board. Registered with offices, or even not registered with the real estate board, but we legally registered with the companies or company whatever of Jamaica. And it gives the address. Give full rights unimpeded to display to potential investors and create drafts and proposed layouts for lands part of Denby Crawl contained in certificate of titles with volume 1299 folio 350 registered to Valerie King of above address. It is understood that this is a first step towards an agreement to be reached reacquisition of and disposal of assets between the parties. This permission letter is binding upon all heirs and executors and is evidence of a more formal and detailed joint venture and development agreement to be signed between Carif Limited and the undersigned. So in this letter, it's not only separated that there's a joint venture agreement and then there's a development agreement, which we file are related, but nonetheless, signed Valerie and King. I want you to see the signature, of course. Alright, so in short, as I've said to you before, I'm going to present all the evidence to you and all the facts. And when these things happen, you should know. You're a Jamaican, you're an investor in Jamaica. You have the right to know. You have the right to stand up and fight these matters. You have a right to protect your interests as a Jamaican citizen against irresponsible rulings by these people. You have a right, and you should protect that right. I just flashed on the board. I don't want people to just for evidentiary presentation that these are the people these people just defrauded with their nonsense and illegal ruling because they're violating the Constitution. And it's for, again, the developers that are out there, the real estate board, the ministry, the government, the prime minister, the leader of the opposition, any and everybody with interest, homeowners, to stand up and demand that this court ejects from its system judges like these, that this court is reformed, that the auditing process begins, that this is a first step of cleaning up corruption in this country. Because unless it's done, corrupt people will always go to the courts and make backdoor deals that results in judgments like this, which are obviously abuse of the Constitution, abuse of people's constitutional rights and civil rights and human rights. It's an abuse, and nobody should be subjected to this. As I've said to you before and will point out, look at Haiti, what's happening in Haiti. We're not so far from it, because when people get to the point that they're fed up and they're not going to deal with this anymore, what happens? Chaos, chaos, chaos. Everybody that's listening, please take this seriously. I only want you to subscribe to help get the message out. Share it to get the message out. Not trying or working to make money off this. This is not something I wanted to do. I'm a very private person, but I've been compelled to take these actions because I don't think I should come on this planet and live and see all of this illegal stuff happening and just not do anything or say anything. These are the people who allow them to steal us out of Africa. They are the descendants of some of them same people who sell us out of Africa as slaves and take away rights. And though they ended up in this part of the country because of the very acts of some of them own people, we can't allow this to be to continue. We have to put a stop to this kind of corruption. It's corruption that put us in the West, took us out of motherland Africa, that's now destroying our little country of Jamaica and destroying our rights as people of Jamaican descent. Or just people who are in Jamaica want to do legal and upright business. So thank you for taking the time. I'm going to be dealing with the other issues. I'm going to supply you with as much information. I'm going to be sending out letters to these various entities I mentioned, but you can play a role. Don't allow this to just stay with me. Contact your bank, contact the real estate board, contact these developers and share the videos with them as well and say this is what's happening. Contact your legal representative. Speak to your attorney about suing Mrs. King if you're in one of those situations where you are a joint venture partner or an investor in this development in Clarendon, that you signed papers and that you were waiting for an outcome from the courts. Sue them. I am fully capable of being there for you in support of that. Don't allow Mrs. King to rob you, or allow these judges who sit down irresponsibly allowing people to be robbed, because it's not only illegal, it's against the court's own rules. One of the first rules in the court is dealing with matters expeditiously and justly. You can't tell me any of this is justice. Thank you. Have a great day. Enjoy your Sunday. It's pretty nice outside. Kind of hottish for me, but I'm going to go walking anyway. So thanks for taking the time. Please subscribe, share, help me to fight this. That's all I'm asking. And it's not just about me, because again, I could walk away from this and not even bat an eye. But I think injustices need to be solved. And when you're dealing with business, there should be consequences to illegal activity. When you break agreements, and those agreements were decided on by you, then you should pay consequences. Mrs. King is not a victim. We are the victim. The joint venture partners are a victim. The entire country are victims because of what these judges did on Mrs. King's behalf, or rather on Alexander Williams' behalf, because as I said, not even Alexander Williams could come to any intelligent person and present that kind of thing and say it's a worthwhile defense, because he doesn't address anything in there that deals with us as a real estate developer under the act, under section 35 of the act that he even cite. And the semantics of playing on with words is what a lot of attorneys have been doing, but that is a crime under the Law Reform Fraudulent Transaction Act, and judges have to become more alert. And as I'm mentioning judges, every judge, and I keep saying it, every judge that has the integrity to want to do the right thing, you have to start standing up. You should not allow judges who come in there with incompetent, unqualified, corrupt, just abusive of their position to come in and do these kinds of things, and allow you who want to do the right thing to be painted in this broad brush scenario. It's a crime against humanity, and you need to stand up, because if you don't stand up, you will be counted as one and part and parcel of the whole mess. Thank you. Have a great week, and you'll be hearing from me. Have a good one.